All right. Hi, this is Curt,
And Brad Pinsky.
and we're here for another edition of Fire Law Roundup for December 23rd of
Happy
2024.
holidays.
Yes, happy holidays to everyone. Let me make sure I get this clicked. I got it. I got it. We're not going to have any
No more
feedback.
feedback. Awesome. Okay, well, the Bonton Roulette, let's start down in New Orleans,
Mm.
where this is really, really confusing. I will try to recite the most relevant of the 3, 4, 5 pages of facts and decision, but
Well,
this
let
is
me let me just let
complicated.
me let me start out by saying I included a lot of the facts because I think it's relevant. I think to
Sure.
understand the legal decision, you got to understand the facts. And the facts I think are to the average firefighter, I think the facts are pretty interesting. In fact, some of the things that happen, we've gone through in my fire department. So, it's the type of starts out with maybe a little bit of peer pressure
Yep.
of hazing, and then to some overt you got to be kidding me stuff. But
Right, right. So okay, so the best I can do, let's look at some of these facts.
Mhm.
So again, we're in New Orleans. We have a fire captain who alleges that there have been a number of instances of race discrimination and conspiracy and some due process violations. So the court has reviewed these and has determined that two of his race discrimination claims can proceed, but the remainder gets dismissed. And so here's some basic facts, right? He's a black male, 20-year veteran of the New Orleans Fire Department. And he claims that a white male began to harass him because he refused to participate in a boycott of overtime work. As an aside, just if you stop there, I didn't think this was going to discrimination. I thought we were going to get somewhere on fair labor standards violation.
And I'm not sure. I'm not familiar with Louisiana law in terms of collective bargaining. I know there's unions. I'm not sure. I think they're more meet and confer than there certainly is an arbitration. But it's almost like you don't even want to mention that because it confuses. Are you being discriminated on account of your race or because you were screwing around with what the union asked or ignoring what the union asked? And
Right.
when the union says don't accept any overtime, when you go against that, I mean, that is your right to do that, but there's going to
Yep.
be consequences. I mean,
Yep.
let's face it.
Exactly. And so I think here, well, the allegations are that because this isn't a court finding, this is
Right.
just the court saying he can go forward. But so he alleges that a captain who was a white male began harassing him over this, refusal to participate in the overtime boycott. And so he kept accepting overtime work. And so he believes that he's being harassed. Now, here's the funny thing, though. He says that he's being harassed for his refusal to participate in the boycott. Doesn't that automatically defeat your discrimination claims?
And I
Now
think
you
the
have a
court,
totally legitimate,
and the court
illegitimate
more or
reason.
less says that. The court more or less says that, in the decision. And again, I didn't look at his complaint, so I don't know if he alleged that. But I would try not to even let that get into the court proceedings because
Right.
it just confuses the issue about whether it's race or not. So, and maybe he's
Exactly.
being honest, and
And,
but.
yeah, but I mean, this is the more interesting part of this case is that lawyers are faced with, well, if I plead this or if I say that, it might defeat things. He would have been better off giving no reason why and then
Mhm.
let them come back and say either A, we didn't harass them or discriminate at all, or B, we did, but it was based on something else. So they
Mhm.
admit we're harassing him, just not based on his race. It puts the department in a lose-lose position, which is
Yeah.
how I think I would have done it. But either way, and so look, suffice it to say, he's being singled out and he's being set. He feels that he's being set up. He was, told to come see the chief, but he wasn't really told to come see the chief. That was a
Yeah, did you
setup.
follow that? Let me kind of run through that. As I envision it now, as I envision it, he's fourth in. He's the fourth arriving engine at a working fire.
Oh
Okay.
no, what was reported as a working fire, but
What
there
was
was no
reported
smoke
as a
shown.
working fire. Okay. But apparently, uh, the first three companies, first three engines, and whatever ladders and everything, they handled it. So he wasn't given any direction. Now he's the captain, and for whatever reason, his two of his five, I don't know if he had four or if he had three, but two of his firefighters get off the rig and go inside without him telling them to. And he's waiting at the rig for an assignment. So at any rate, they go in. They come out shortly thereafter, and he talks to him and says, "Hey, look, don't be rushing off. I'm the captain. You stay with me."
And they're fourth too, so they probably shouldn't be going in anyway.
Well, they should, because what if there's an assignment that requires them outside the building? So at any rate, the next thing that happens, and I can so see this happening. I can so see this happening. That one of the captains apparently is upset that this particular captain, Dyer, did not get off the truck and go help. At least that's how this captain saw it. Okay. So now the captain apparently gets on the radio, pretends to be the chief, and says, report to the command post. So he tells this guy's company to report to the command post. So now and they were clearing the scene. So as he gets close to the command post, this captain apparently is driving away, and he said something nasty.
Don't stay, get off the pump panel.
Yeah, get off in other words, implying that, he was dogging it by staying at the truck, and his firefighters knew enough to go in and help, but he didn't, and so on. So at any rate, he goes to the chief, and the chief knows nothing about it. So it's pretty obvious the chief didn't tell him to come to the command post. So now he's upset. And so now he contacts that captain who gave him the business and says, "Where are you going?" And he goes, "Well, I'm going back to quarters." He says, "I'm coming to have a conversation with you." Which is kind of escalatory, I mean, guys, firefighters will do what firefighters do. You don't need to make, at any rate, he now pursues him to the station. Apparently now the captain who pulled the prank is now upset that he's gonna, get physical with them.
And there's other firefighters standing there.
Right. And he reports it. And so the chiefs are aware of it. But, another thing he says is the chiefs never told him not to go there. So the chiefs were aware he was going there. They never told him not to go there. Really kind of confusing, facts. At any rate, he shows up. They have a little verbal disagreement, and they both end up getting disciplined, except Dyer ends up being initially charged more seriously than the real perpetrator
Which
of the prank.
Makes some sense. He pursued him, as you said. So I happen to, I can see why, right? And,
he was initially charged with, I think it was violating Rule 25, which is potentially terminable, versus what was the other
21.
Rule? 21, which is really just a reprimand. So the perpetrator of the prank ends up getting reprimand. He's now facing more serious, but then the department, and he characterizes it as the department couldn't make its case.
Right.
Whether that's true or not, we don't know. Bottom line is the department decides to reduce the charges and then finds him guilty of, basically the same thing, like, being disrespectful and so on. So, he in turn takes that to mean that basically he characterizes it as a due process violation, because he's charged with A, he comes to the hearing, and lo and behold, now he's charged with B. You and I know that's a lesser
included offense.
Lesser included offense. So that's not and the court didn't even characterize it that way. They just said any sort of due process. If there was a due process problem, the fact that he had a civil service hearing after the disciplinary hearing would have clarified or provided him with any sort of due process. So
then we get to the other part of that discrimination claim, which is he applied to become for a promotion, right, as a chief, and he didn't get it. You could copy and paste this from every other, failure to promote. He said he was more qualified, he had more time, he had more experience, and a lesser person got it. So, look, they're going to have to come forward and say why we gave it to somebody else, but now he has a disciplinary history. So that could be it. That could be the end of it. Who knows? They'll get to come forward. So, and he claims he's being treated differently with some overtime hours and things. But so the court gets rid of, in short, all of these except for two disparate treatment claims, right? You're not treating me the same, or you're treating me differently based on my race. And so those two claims proceed. Everything else goes away. He's going to have a hard time on this, because right away the flavor is, you're just not getting along in the department. You don't agree with your union, which is fine, but people don't necessarily like you. I don't know. I haven't yet seen anything based on race
Yeah, I think he's got a tough case. And, you know, what concerns me when I see a case like this, and I don't know any of the details, so I'm
We
just
don't. We
going
don't.
based on what I see. When I see somebody who files a complaint about this happening and files a complaint about that happening and says, you're picking on me here and you're doing this, you know, anybody's entitled to have a problem. Okay.
Yep.
But when you keep having problems and you keep having problems and you keep having problems, maybe it's not everybody else.
Yeah, exactly. But those people, and I'm not saying we're not saying that he's one of them, but those
No.
people never realize they're the problem.
Of course, and that's that's what's got me going for my graduate degree in forensic psychology. So,
which benefits us so much here because you have such a different take on things. I love it. Okay, well, let's go to North Carolina. This is a really, really interesting, easy case. So, in short, we have a medic who fails a drug test. Obviously, the fire department, Otway Fire Department, has a policy against using illegal drugs, and he takes opioids, which stay in your system for 4 days, but he doesn't take them while on duty, and he's not impaired. So, which is really the important standard, right? Not impaired, but again, they stay in your system. This is very much like marijuana, but very different, or medical marijuana at least, but very different in the sense.
The principle, the testing principle is the same.
Same.
That the test, most of the tests do not test impairment.
They test
whether or not you have metabolites of it in your system.
Right. And here he does, and he said he doesn't use it, and he's not impaired, but nonetheless, he fails the drug test. So he's claiming that they failed to accommodate him by engaging, which is minimum. Everybody should do this whenever anyone comes to you, at least engage in reasonable discussion about what could accommodate, right? At least look at accommodations. Now, the standard is not to accommodate. The standard is to reasonably accommodate, but at least have the discussions of what accommodations you would like and what we could accommodate, what is reasonable, what is not. And so he claims they didn't even do that, which is problematic because that means you haven't even talked about it, right? And if the judge finds you haven't engaged in a meaningful discussion about accommodation, you lose there. And then and that's an easier standard to prove than is there an available reasonable accommodation, right? Is there one available and is it a reasonable? But
and in his case, it sounds like there is a reasonable accommodation. Now, it's a little bit more expensive, but it's a more comprehensive test that can actually measure impairment as opposed to whether or not you've used opioids in the last 4 days. And in his case, he was using prescribed opioids. And then his second test that he failed, there was another medication. I forget exactly what it was.
Benzos.
Yeah, and
benzodiazepines.
Yeah, and I think it was Xanax was the prescription, and which is, I believe, a Benny.
Depressant.
But at any rate, his accommodation would seem to be reasonable. And actually, there's some cases out there. Now, courts have not bought into this, but there's cases out there that talk about whether or not a test that measures metabolites is even a valid test, because what we should be looking at is impairment. And Brad, unless you're standing still very, very carefully, it looks like you have either dropped off or you're frozen there. So I'm not sure. I think we've lost Brad. So probably what's going to happen, he'll either pop back on or he'll log off and come back on. So, but again, there are cases out there that have argued, the plaintiffs in the cases have argued that fire departments, municipalities should not be testing with tests that cannot measure impairment. The courts have rejected that and said, no, as long as there's a connection between the what they're measuring and your fire department rules and regulations, we're not going to say it has to test present impairment. So, but in this case, I think he's got a stronger case. And I'm really kind of surprised. He's a combat veteran. He had a number of different ailments as a result of his service. And let's see, Brad is sending me Brad's lost his internet and it is not back. So it looks like I'll be solo here for the remainder. And I'm just gonna excuse me. can. I'm telling Brad, log back in when you can, and we will march onward. And Brad's in a new house. He's actually down in Florida, and so I think things are not fully settled for him in his new accommodations. So, but at any rate, we've got this interesting claim, and we'll see how it pans out. But certainly, fire chiefs out there need to be aware of your obligations under the Americans with Disabilities Act. And as Brad was saying before he got knocked off, there's a duty to engage in an interactive process with the employee and try to accommodate them to the extent that you can. Okay. So Brad is saying he's going to use a backup internet, and it's going to take him a couple of minutes to get that active. So we will see him back shortly. Okay. Next case here is out of San Antonio, Texas. We've got a fire captain who apparently has long COVID. The captain is a 28-year veteran. He, in the allegations in the complaint, he says that he's always been in busy companies, but after he first contracted COVID and then he had it a second time, he had to move out of the busy companies. He just couldn't keep up with the the energy level required in the busier companies. And he also is suing for disability discrimination, alleging that the department has failed to accommodate his needs based on the long COVID. And it's a couple of unusual parts to this. Apparently, during the course of his disability, he went off, and which it was treated as a job-related condition, so it was a workers' comp issue. The department, a couple of things happened. Whether the department had control over this or not, I think remains an open question. But his doctor was an accepted provider through the city's workers' comp program, and then all of a sudden he was not. And so he's alleging that there might have been some sort of a decision made by the city to kind of move his doctor off the approved provider list. So that was sort of issue number one. Secondly, they sent him at some point to an IME, an independent medical exam, to a doctor and or a medical firm that did not believe there was such a thing as long COVID. And we got a lot of conspiracy theory people out there and people with different perspectives on a lot of different things, but this particular medical practice or this particular doctor felt like there was no such thing as long COVID. So if you're sending somebody who has a bias against the condition that you have, believing that the condition doesn't really exist, it doesn't really seem, I don't know, fair to send somebody to somebody like that. But at any rate, there was some consequences to that, including the fact that he was not allowed to go to certain medical specialists that he needed to go to. And when he later ended up going to another IME, the other IME said, no, this guy needs to go to these specialists and so on. So at any rate, we've got a disability discrimination suit against the city of San Antonio by this particular captain over long COVID. So I haven't tracked long COVID, but this is not the first case. I don't think I've got a half dozen, but I've got somewhere 2, 3, or 4 cases on that long COVID. So, and here he is. So,
oh my God, I hate live broadcasts, right? Because for some reason they're working on the internet out front, and
Yep.
I'm like praying they don't get it. But anyway,
well,
they took me out. Where did you
I told
leave
him you're
off?
in your new house, and when you get up into a new house, things happen. So, but we finished
New house,
up
new
that.
neighborhood.
Yep, we finished up that that was the New Orleans case, I think, and now we're on to
Yep.
San Antonio. So this
The
is
long COVID case.
the long COVID case. So I kind of went through the facts. Anything stand out to you, Brad? Anything
No,
stand out?
I think it was. I think it's an interesting case, but look, long COVID is going to be a disability, and
Mhm.
I don't think there's anything groundbreaking, except that it's COVID. We've never seen something like long COVID, in
Yeah,
this regard.
I think it's more about how the city handled it in terms of removing his doctor from the workers' comp network so that he basically by removing him from the workers' comp network, he could either go under his own insurance and then pay the out of pocket on his own, or find a new doctor. And then they sent him to an IME, to a doc that didn't believe that there was such a thing as long COVID. And as a result of that, there was some specialists that his doctor felt he should go see, that he was denied. And then all of a sudden the city sent him to a real IME, and the real IME said, wait a minute, this is a real thing, and he needs to go to those specialists. So there's a question there about what happened in that gap and why it happened, and whether or not.
And the one thing, as you won't be shocked, maybe the viewers will, but the one thing I looked at is, where's FMLA? Because family medical leave could have come into play. And the reason I said that here is because under different laws, as you and I talk about, sometimes you could see your department's doctor, like with workers' comp IMEs. Sometimes you have the right to see your doctor. So with an FMLA request, you would have the right for your doctor to evaluate you, who then could have issued an opinion on it. I just think if you allege both, you really screw with, okay, you can see your doctor for this, department doctor for that. And it just may have gotten something, but ultimately the department IME realizing, like, okay, you've got a real issue here. Long COVID's a real thing, saves him. I think saves him. But the other question I had is this: how does he know he contracted COVID on duty? I mean, how does anyone really know?
And that's a good factual question. Okay, it's always a factual question, but the city treated it as workers' comp. So
right.
So
as they should. As they should. And frankly, with COVID, since they're going to say stay home anyway, right, or whatever, then I don't think it matters. You got the illness, you have the effect. So
it is. What is fascinating about this is it does involve the intersection. You've got the ADA, you've got Texas state law, we've got workers' comp law. And that is sort of the joker in the deck, because that law mandates that the fire department pay his medical bills. But you've got to you got to do it the way that workers' comp law requires. So you can still go to your doctor, but we're just not going to pay for it. So I think that's sort of the wrinkle there. And whether or not that was retaliatory, and I'll go back to my forensic psychology a little bit, and bias. Okay. And when the front office believes that somebody's a phony, or believes that somebody's stretching out an injury, okay, they make decisions that in a different light really can't be justified. I'm not saying that happened here, but it kind of reminds me of some situations where I've been involved in front office type decisions on employees. And when you believe that you've got a good firefighter who's just on hard times, you go one way. And when you believe you've got a phony who's stretching out the injury and milking the system and so on, you treat them differently. And sometimes you're wrong.
And the process needs to be the same, right? Your point is treat everybody the same. This reminds me of things you say often about disability, about discipline.
Yeah,
with discipline, we presume someone's guilty or innocent. We treat them differently. And we'll investigate it if we believe it's a valid claim, but we won't investigate non-valid. Same thing. You investigate everything.
Absolutely.
Right.
Absolutely. And I go to those who've been through my classes know about the index card, and it's so important that you treat everybody like they're on the top of your index card. If you don't know what an index card is, we're not going to get into it here, but those who've been in my classes know, you just treat everybody like they're on the top of the index card, and you won't go wrong that way. So.
Right. True. Okay. San Diego.
Sure.
San Diego, we have the Firefighters Bill of Rights. And, everybody should, if you think you know what a Firefighters Bill of Rights is, you don't unless you're in that state, because they're all different. I think they're generally have the same theme, but they're not universal.
Some of the states are similar. Yours is unique. New York is unique.
New York is crazy.
Yeah. But like California, New Mexico, Florida, those are all fairly similar. Virginia, those are all fairly similar. But California is, it's similar, but it's got some unique parts to it too. So,
right. And so here we have the local has filed suit against the city. They're alleging that the city's refusal to provide details about allegations that led to a disciplinary investigation violate the state's Firefighters Bill of Rights. And, if you just stop there and said, okay, details, are we entitled to details? Some details you are, some details you're not. Right. So here's the history of it. So we're in June of 24. This is not old. And a firefighter, last name Ortiz, responded to an emergency with paramedic employees who were privately employed by another city. But they're under contract with the city to provide paramedic services.
I think it was a private EMS provider, FLC.
Yeah, I've never heard of the company, but it doesn't mean anything. So a paramedic disregarded, allegedly, I guess, the airway paramedic, right? The paramedic who's in charge of intubation, et cetera, and performed issues with another employee, Falk employee, who was a licensed paramedic, but who was getting field trained during the call. So 2 days after the call, on the 24th, the firefighter receives a call which says, a commendation for actions on the job, which, right off the bat says, hey, great job, but June 26th, 2 days after that, and 4 or 5 days after the call, there's a follow-up email with regard to a complaint. And so this is stop here for a second. Everyone always says, do we have the right to see complaints against us? And the answer is, it depends where, right? With cities and municipalities, forget on the employment side, if somebody files a complaint, or like with the state division, normally you don't have the right. I can't speak for every state, every county, city, but normally the complaints are confidential until they're being disciplined, right? Until there's charges against you. Then, of course, you have a right to know what you are being accused of.
Right. Yeah.
Yeah, I mean, you can't defend yourself without knowing the charges. But at an initial stage, just because a complaint's made, at that stage, you don't necessarily have the right to know what it is. But, if you're going to be interviewed about it, they still don't have to tell you why they're asking you questions.
Well, it depends.
I don't believe
it depends. Now, in California, this is the key thing. If it's a disciplinary, if you can be disciplined, they have to tell you up front. There are certain requirements. But if it's QIQA, quality assurance, quality improvement type medical EMS, where there is no discipline, they don't necessarily have to. And that's the challenge here, because we've got something that is sort of masquerading as two things. On one hand, it's a QIQA, which is confidential and so on. On the other hand, we've got a disciplinary investigation. And how does the fire department separate the two of them? That, I think, that's the unanswerable.
Right. Let's discuss that, though, because I think that's the big part about this case, is that when you have two parallel investigations going on, which is the issue, and you have two parallel standards, QAQI is not intended to be disciplinary.
Right.
But it doesn't mean that when people testify or give information, it can't suddenly become disciplinary. And, there's the problem I have seen in some issues is where the person being investigated is called in to talk about their report. And now they're giving testimony. And can that testimony then be used against them? They may not be represented by the union. And
some places immunize that it can't be used for any other purposes. So now if you ask the firefighter, let's just say, what was the first thing you did? I did A, B, and C. If you ask that question in QIQA, in a state that prohibits it from being used, your answer to that cannot be used. If it can be asked again in a disciplinary investigation, but then all the protections that go along with the disciplinary investigation, but your answers cannot be used. And I don't know about California's QIQA, but if the answers there can be used across the board, now you've got a fair question, because the answers could end up resulting in discipline, which is the key language under the Firefighter Bill of Rights.
Yep. Let me throw out New York's law only because the only one as liberal as California is the state of New York. And New York does something interesting because everyone always tells me, oh, QA/QI is totally confidential. Yeah, unless you read the law. If you read the law, it says any statement made by somebody who later becomes a defendant is not confidential, is not protected. So if you became a defendant and it doesn't, I don't think it says in a civil lawsuit. It could be criminal, it could be civil, could it be disciplinary?
So what does confidential mean? Well, so what is confidential?
Nothing. It means nothing. Absolutely nothing. So, but yet, and it's in a number of the, it's in the EMTs, it's in paramedics, it's in nursing. The same language is all throughout New York's. So it always, makes me think, well, if I participate in QA/QI and I give my side of the story, it can be used against me. I don't want to be honest.
I certainly
you don't want to say, I screwed up.
I mean, I certainly wouldn't hesitate to cooperate with a QA interview if the answers could help me. The only concern I would have is if it's going to hurt me. So what protection does that confidentiality law give you? None. That's crazy.
Nothing.
Another reason to stay out of New York.
So many reasons. So anyway, but I think this issue is such a great issue because people will oftentimes see themselves in that position. And then if you say, let's take it a step further. Now we're just making this up. This is not this case, but it opens such a good Pandora's discussion, which is, okay, now I refuse to participate in QA/QI because I don't want anyone, because listen, I say something, you can say it's confidential. Okay. Oh, I heard it from Joe. Joe who? I just heard it from Joe. The same thing I happen to testify about at QA/QI, you heard also from someone else. Maybe you did, so it's not protected, or maybe you heard it from me, so it is protected. But things leak, right? There's no secrets in the fire service. Let's be fair. So I think this is always such a good, hard issue about on the paramedic, on the EMS, on the QA/QI side. But it's not just that. What about after incident analysis, post-incident analysis, which the NFPA wants us to do, federal regs, the fire brigade standard wants.
There's no confidentiality attached to that.
Right. But what happens if you refuse to participate in it? So, I mean, this whole thing, the whole issue, discipline and the right not to incriminate yourself and testify and Weingarten, you don't have union reps there. And do you get a union rep at QA/QI? I mean, if it could be a disciplinary interview.
Under the Bill of Rights, you should, if your answers could result in, and they have a list of things that constitute discipline. Now, certain things aren't disciplinary, like, counseling and that type of thing. But once it triggers discipline, they have these certain procedural rights. And,
All right. And so the question is, at QA/QI, could you have done it better? Right. But is one question. But the question also is, were you wrong? And was that incompetence or was that willful misconduct? Right. It's one thing we can train you. It's right to get better. We can remediate you. It's another thing to say you willfully disregarded the protocol. You have 3 prior histories of it, et cetera. And QA/QI is going to go there. There's no way you're not addressing why was the error, made. Intentional, willful, incompetent, and it leads to what should the result be, right? Again, incompetence, I'll train you.
Well,
willful misconduct?
I do think that the San Diego firefighters in filing this suit are going to be doing everybody a favor. That maybe the court isn't going to be the one to fix this problem. It might have to go to the state legislature. It might be a combination of the state EMS and the state legislature. But, this certainly needs to be rectified and answered. And I can see why it's not something that's going to be answered between the city and the firefighters. This is beyond that. So,
but we definitely see the firefighters' concerns. I mean, there's no question, right?
Absolutely. Absolutely.
Okay, well, and then ending on an easy one, Massachusetts has settled an FLSA lawsuit for just over $100,000, but the important part, and I swore we just covered the same
We
one like
we
last
did
week.
we did not. I think it was earlier this year when the suit was filed, but now
Okay,
it's been resolved. Okay, so
settled.
yeah,
Yeah, and the argument was that, which is so common, right? They fail to include in the overtime rate the actual base wages, which has to include everything basically you're guaranteed to get, stipends, etc. So here it's wage augmentations for active shooter response stipends, failed to pay firefighters for 3 hours of each 24-hour shift. I don't understand that
yeah.
one.
I
I
think
got to tell
well,
you.
if that would be 21. If you think about it, that would be 21 hours each shift. Then you multiply that times two. That's 42 hours. So
Right,
yeah,
but if
so
I don't know
well, they
what,
probably if you have a 4 shift system and you divide there's
okay,
168 hours in a
53
week.
hour week.
No,
Yeah.
so there's four, if you have 4 shifts and there's 168 hours in a week, you divide that by 4 and you come up with 42. So all firefighters
Okay.
on a 4 shift system work 42 hours. So yeah, I think that's a stretch. And the court, or from what I saw, they didn't particularize that in the settlement. But I think what they were getting at was that some weeks, not every week, but some weeks they work more than 40 or 42, and they're not being compensated for it. And somehow that all washed out, and they've got it all resolved. But I'll tell you, the
Right.
biggest problem with these, and we talk about this in the FLSA class, one of the biggest problems we've got is we have software that it works for people who work in Home Depot and Coca-Cola that work 40 hours a week and overtime after 40, but
Yep.
it doesn't
And there's
work,
no other stipends or longevity pay or
right?
paramedic pay or any of those
But
other
but
things.
when you start working what the shifts that most firefighters work, and then God help you if you're on like a 4896 or some of these, the California modified role or some of these other you know,
Pay day issues. And,
it becomes impossible. And the software provider says, all right, you pay us 80,000 a year and this is what you get. And he's saying, well, you're not doing it right. Well, this is how we do it. So you got to figure it out. So now people's pay stubs, when they're working, they're actually working a 24-hour shift. It says they only worked 8 hours and their pay stub says 8 hours, but they actually were, and then it just gets confusing. What am I getting paid for? And so many
right.
firefighters as well as city administrations are frustrated with the software, the payroll software out there. Nobody's really got one that is able to do everything that we need for the FLSA for firefighters.
Oh, and now you're putting on my, engineer
Yeah.
hat here.
Oh, there you go. Well, I'm going to tell you,
Um,
if you think about do a Venn di this is what I do in class. We got a Venn
Venn
diagram,
diagrams.
right? Here's everyone in the United States, okay, is in this Venn diagram. And then a certain segment of them work for government. And there's special rules in the FLSA for government. And then smaller circle within that circle are firefighters, okay? You're talking about out of 330 million people, you're talking about maybe between 4 and 500,000 employees. And when the companies are looking at how much are we going to invest, they're going to invest where most of the employees are. They're not going to invest in getting it perfect for such
right.
a small percentage of employees. It's
Yeah.
reality.
And it's a lawyer issue too, in the sense, again, it's you wouldn't go see your foot doctor for a brain aneurysm, right? So
Right.
the lawyers too think they know everything. And
Yep.
okay, I know HR issues for a normal person, but you're
Mhm.
not a fire service, right? And the FLSA will come and bite you. I was down here in Florida doing HR manuals
Mhm.
for large departments, and I'm looking at their other manual. I'm like, who wrote this? It's written for a Home Depot type employee. I mean, when you're talking about 40 hours or,
Mhm.
and things don't make sense. And then they're talking about, you'll, your clock out at the end of your shift. It says there's never a reason to stay late. I'm like, that doesn't fit. I mean, there's so many things that you're right. The normal world just doesn't fit to the fire service
Yeah.
world. And you can't use a normal book, a normal attorney, a normal whatever for these types of things. And I don't know how to educate people that it's okay to have specialists, if we're allowed to say that.
Mhm.
People who focus, people who concentrate on
Yeah,
these
concentrate.
things.
I think concentrate's better. It's more palatable to the Supreme Court. and disciplinary counsel.
Fair. Yeah, and you know, in New York, I can't say we specialize. I represent
Right.
500 fire departments, but I don't specialize in it.
Yeah, no, we
Right.
can't either
We can
in Rhode
focus.
Island. Well, we generally use the term concentrate. My practice is concentrated. So yeah.
Yeah. Anyway, our viewers won't care, but nonetheless, this is why we have such a hard time finding people who do this work.
We've got some. I think most of our listeners are firefighters, but we've got a few firefighter attorneys out there, and some others that listen in as well. So, well, that's it. And next week, I guess I don't know if you want to do 2 or 1. We've got to at some point, I think, do a year end.
Right.
We'll see what the cases look like this
Let's
week.
see what the cases exactly.
Yeah, we'll take a look at what the cases are going to look like. There might not be a lot of new decisions coming down. So, but we'll see.
I swear it was just months ago where we did the last, the last year. I mean, this year has gone so quickly.
Yeah, I know it. I know it. It's incredible. So, and we are waiting.
Happy holidays to everybody.
Yep, certainly. Just looking forward here. We're supposed to be getting some clarification now on OSHA's new mandates, and supposed to be in the first quarter of 2025, their final decision on what they're going to do. We also know the president is coming in. The new president's coming in with a mandate to reduce government regulation. And so we'll see how those two issues sort of interplay. So that'll be interesting, and
Yeah, my bet is, I'll give my prediction. My prediction. I've been vocal with this, and this is not that hard of a prediction because I'm relying on something that OSHA came out recently and said is they don't think that all of these regs will fit perfectly for a volunteer agency. So I think you're going to see. One, they're going to have to figure out what the heck a volunteer is. Is that paid on call? Is that not? Right. So I challenge them to try to figure out who this could possibly apply to. They can't do it based on incentives. So I don't know how they're going to do it. But as to career departments, I think this is all going to apply. I think they're going to parse out a lot for the volunteer departments. Unfortunately, I say unfortunately because everyone's screaming about the costs on these, and yet the municipalities need to provide the costs. We should stop fundraising so we can afford a physical or a new vehicle, right? So I don't care that the costs go up. Just make sure the municipalities, who are the employer under OSHA anyway, in most instances, many instances, so district, government, whatever, I don't care what it is, they got to provide this stuff. So I hope that all of these rules are enacted for volunteer and career, but it's not going to be that way. The volunteers are going to get exempt from most of this.
Yeah,
that's my prediction.
So, and the other, I guess my Christmas wish would be to eliminate unfunded mandates, so that if government's going to mandate it, federal government's going to mandate it, which I think everything that I read in there is pretty good. I don't see anything that is against firefighter safety. I think it's all pro firefighter safety. But if you're going to mandate it, if you're the federal government, you're going to mandate it, get out your checkbook or don't mandate it. Okay. And at the state level, the same thing. If you want to mandate things, you want to mandate schools got to do this and fire departments are going to do that and police departments got to do that. Fine. That's good. It's all good stuff. Fund it. Get out your checkbook. But don't be mandating things that you're not willing to fund.
And that's really the Ramaswamy, right, Elon issue now, is that people are in a position, they've got to create, and this is quoting Vivek Ramaswamy, who I listen to podcasts. He's brilliant, by the way, but he says, people are hired in federal government. They don't have anything to do, but they got increased ability to increase their staffing. So they find a job for themselves and they they create regulations, which are really legislative, not executive. And then they oversee the enforcement of them, which is executive, but they're not funded. And so so they're creating, I'm going to burden you so I can have a job. And that's Vivek Ramaswamy's belief.
I think that's a little cynical, but I think the principle is right. I think his principle of what's happening, but I don't think it's because I'm trying to justify my job. I think that many of these people honestly believe that this is going to make the world a better place. And the people on OSHA, people I know that work for federal OSHA, they genuinely care about worker safety. these folks are really dedicated to that, right at their core. And what they're doing does advance worker safety, but I think they need to be bridled somewhat. And if you're going to mandate it, you got to fund it. If you can't fund it,
Absolutely.
if it's so important, the federal government has to mandate it, then fund it. If you can't fund it, then what are we doing? Right?
Right.
What are we doing?
Agreed.
Yeah. So,
well, we're going to be the FAA with 1965, equipment. So.
yeah, really.
Okay, that's it.
All right. Well, that's going to do it for another edition of Fire Law Roundup. We'll see everyone next week. And Merry Christmas, Happy Holidays, and we'll see you before the new year. And we'll have our annual. We'll do. You want to do the
Roundup?
Five craziest. So, all right.
Yep.
That's going to do it.
Absolutely.
Brad, we'll see you. Merry Christmas. Have a happy
care, everyone.
holiday.